Welcome to our International Speaker Series. My name is Angela Zhang. I'm the director of the Philip K.H. Wang Center for Chinese Law. It is my great pleasure to welcome Professor Jose Alvarez from NYU School of Law to come and give us a book talk of his latest book, The Women's Property Rights under CEDAW. And so before Professor Alvarez gave his book talk, let me first introduce him. He is the Albert and Rose Robin Professor of International Law at NYU. And before coming to NYU, he was the Helmington Fish Professor of International Law and Diplomacy at Columbia Law School. He has also taught at Michigan Law School, George Washington Law School. At NYU, Professor Alvarez teaches courses on international law, foreign investment, and international organizations. And he served as president of the American Society of International Law between 2006 and 2008, and was the co-editor-in-chief of the American Journal of International Law. So I'm really, really looking forward to his book talk today. And I'm also very pleased that my colleague, Frank Xinhe, a professor at our law school, who also studies Chinese marriage system, will join us and comment on Professor Alvarez's book talk later. And we'll leave some time for the audience to raise questions. So before further ado, let me invite Professor Alvarez, and I will share the screen of this presentation.
Well, thank you, Angela and Frank, for doing this. I look forward to your remarks and learning from you on this. So the book is not yet published. It'll be coming out in March, probably mid-March, from OUP, Oxford University Press, and it deals with women's property rights under the Convention on the Elimination of Discrimination Against Women, or CEDAW. A treaty that is one of the most widely ratified treaties on earth, with 189 party signatories. Alas, it does not include the United States, one of the few countries that is not a party to it. And basically, as these two jars symbolize, it deals with the gender of wealth and property around the world, and the efforts by this leading treaty regime to promote the equality of women, to address that gender gap, which is more like a chasm, actually. It is so wide. According to the World Bank, for example, even in the 1980s, when it really looked at this for the first time, the UN Commission on the Status of Women pointed out that women received only 1/10 of world income, own less than 1% of world property. The feminization of poverty is a reality and can be measured in many, many ways: by who owns businesses, by who has access to credit, by who owns farmland. So that, for example, women make up 43% of the agricultural labor force in developing countries, but only 20% are landowners globally. And that percentage is less than 10% in Western and Central Africa, the Middle East, and North Africa. You can also measure these jars and their differences by who has low-paying jobs, who engages in unpaid work, as in the homes, or in the informal sector. The bottom line is, as my Michigan colleague once put it, women are more likely to be treated as property than to have any. And this reality is suggested here by this little circle from the UN, which points out that women's empowerment is key to virtually everything else. So on the left, you see the connection between the equality for women, especially in property. And go back, I'll let you know when we're ready, Angela. So on the left, you see that the women's empowerment can be connected to education levels, to nutrition, to clean water and sanitation, to maternal health, to agricultural and food security, to whether they can mobilize in the community and enjoy health, and of course, access to microfinance. On the table on the right, you see an NGO that is devoted to promoting women's land rights, LANZA, and they point out the connections between owning land, women's ownership of land, especially agricultural land, and the fact that they are safer. Their entire families are more nourished. They enjoy, of course, more prosperity. They're more likely to be educated, and they're more likely to be healthy and resilient. That is, for things in crises like climate change. Next slide, please. So the World Bank's favored response to all of this, as you see in this picture, is to promote land titles. So these women are owning land as symbolized by the little yellow slips of paper that they have. And you can now see from this slide why this is so important. In more than half the countries, laws and customs hinder women's access to land. And of course, it undermines their economic empowerment. And you see the numbers of countries there that restrict it in various ways, so that up to 90 countries where the conditions really and customs in the country inhibit their access to land. Now, some of this attitude towards land titles and the significance that the World Bank attributes to it comes from this path-breaking book by Hernando de Soto, The Other Path. And this has lent the notion that basically protecting land through the World Bank and through international efforts is associated with the Washington Consensus model, because Hernando de Soto is associated with the idea, as in this book, that in order to enhance economic prosperity and prevent, as you see in the subtitle to his book, The Economic Answer to Terrorism, and to prevent terrorism, you need to protect private title to land, you need to deregulate, and you need to free businesses to do what they wish to do. And unfortunately, that means that this access to land titles and the effort to register land has been associated with one particular Washington Consensus model of development. I stress this because CEDAW's approach is a human rights approach and goes very different direction than what the World Bank has done. It does consider the registration of land titles to be important, but it is not saying that that's the key to making sure that you respect women's access to property. Because after all, these land titles that these women are holding can be merely pieces of paper, depending on custom, social, and religious norms. And so it's too restrictive, and also too restrictive of the notion of why we protect the women's property rights, to limit it to this vision that it's really all about land registration. And after all, land registration can get in the way of women's equality if that's the key to everything else. And if women are denied the real value of holding a property, whether or not it's through land titles, then we have not accomplished very much at all. So what CEDAW does that is somewhat different from how the World Bank approaches this is it takes a human rights approach that should be familiar to those of you who are familiar with the Covenant on Economic, Social, and Economic Rights. And that is a trifold duty on states to respect, to protect, and to fulfill all the rights in the convention, which are premised on equality. Respect means the state itself cannot deny these rights to the state, to its own people. The second, protect, means that states have to engage the private sector and use their powers to regulate the private sector so that private actors do not discriminate against women. And fulfill means that the state has a basic right to fulfill the equal rights so that they can provide substantive equality where needed. These respect, protect, and fulfill rights are throughout the convention. What I'm putting up on the screen, Article 11, 13, 14, 15, and 16, are the particular portions of the CEDAW Convention that I consider to be relevant to protecting property. So here, what you're seeing is that the state under CEDAW has the duty to respect, to protect, and to fulfill Social Security, including maternity leave with pay, to provide a financial credit, and to protect women in rural areas in the respects that you see here, including equal treatment to land, agricultural reform, land resettlement, and to provide, and this is very important, adequate living conditions in relation to housing. Also, equality before the law under Article 15 means that a woman can go into court and be sure that she can enforce contracts and also administer land and not be prevented with equal access to court or other judicial remedies. And very significant is Article 16, because many of the deprivations that women suffer are because of marriage and family relations law. That is, the lack of equal rights with respect to whether they can own, acquire, manage, administer, enjoy, and dispose of marital property, including inheritance rights. One thing I should note, Article 14, even though it seems to be restricted to rural areas, 40 years of the CEDAW Committee's jurisprudence has reinterpreted Article 14 to cover women in urban areas and elsewhere, so that Article 14 rights do not just apply to rural women. And that gives me an opportunity to explain to those who are not familiar with human rights treaties the way these work. The convention establishes an expert committee, the CEDAW Committee in this case. That CEDAW Committee is in charge of interpreting the treaty over time through various tools that I will be describing shortly, so that the convention, which was drafted and ratified back in the 70s, has changed quite a bit over time, thanks to the interpretations of the CEDAW Committee. Next slide, please. So CEDAW goes beyond formal equality in all these ways. They basically are not just focused on whether the state's formal laws as written protect women's equality, but whether substantively women enjoy those rights. And so we look into whether de facto and not just de jure women enjoy substantive equality. That means that direct and indirect discriminatory distinctions are the target of CEDAW and the committee. It also means that in addition to all the specific rights included in the convention also says that women shall enjoy equality in all other fundamental freedoms, including political, economic, social, cultural, civil, or any other field. So in one convention, which is, to be sure, focused on discrimination, it covers all human rights. And this means that because of the protect dimension, the state has a duty to make sure that it's not just public authorities, state actors, but also private actors that need to respect the equality rights of women, including for property. And that means significantly that if there is a market actor that is established in your state, that market actor has to take actions consistent with CEDAW, even when that market actor acts outside the state, when it, for example, invests abroad. So unlike many treaties, CEDAW has been interpreted to have extraterritorial effect. It purports to affect market actors' behavior outside the state's territory. And also very significant, but very hard to do, is that the convention expects states to change the social, cultural patterns of conduct that lead to prejudices, stereotypes, including, for example, the practices of minorities or religious groups, such as those who practice polygamy. So therefore, this is a treaty that does not expect states to deregulate, as in the Washington Consensus. It is a treaty that expects more regulation by the state, rather intrusive regulation into what many people in the West would call the private sphere, the family itself. And also in the bottom here, you see that the convention authorizes what it calls temporary special measures. In the United States, this would be called affirmative action measures. That is, special steps that may require women to be given special and additional benefits, not just equal rights to men, but to make sure that we equalize the situation substantively. It may require, for example, hiring by quotas, including in the political sphere. The picture that is here at the left just is there to illustrate how this can apply substantively in the real world. So it depicts an Indian woman, which in many parts of rural India is a widow who has been the subject of property grabbing. That is, the male relatives have now seized on the fact that her husband has died and seized the family property, including the family home. She is stripped of all property. And that means that if, for example, she has only female children, the female children also don't have access to property. And what happens to such women, and it's not just in places like India, they are destitute and often end up in special places of charity for the rest of their lives. They're ostracized socially, culturally, and of course, as I've mentioned, economically. Under CEDAW, this kind of practice, this is a customary practice, not necessarily backed by law, has to be eliminated and indeed criminalized. So basically, what this is saying that forced evictions, even by family members, and homelessness itself is a discriminatory act under the convention. Next slide, please. So where do we get this jurisprudence? So the committee, the CEDAW Committee, has promulgated GRs, general recommendations. Some 17 of them deal with property. It also promulgates COs, or concluding observations, in response to state reports, because every 4 years, every member, 189 members of CEDAW, has to report to CEDAW in Geneva what it is doing to comply with the convention. And at the end of that session, the committee issues its concluding observations, its praises, but often criticisms of what it sees in the state reports. So those are two methods that every state party to CEDAW is exposed to. Only 114 of the 189 members of CEDAW have accepted its optional protocol, which enables individuals and groups of women to file complaints to the CEDAW Committee. And in response to those, the committee issues views. This is the equivalent of its case law. 15 of those views address property and are addressed in our book. And then inquiry reports are where a state is accused of systemic violations, and with its permission, if the state concedes its permission, CEDAW actually can send a delegation to go into the state and inquire, make a systemic inquiry, and may issue a report. 2 of those reports cover property issues, that's South Africa and Canada. The issues addressed as a result of the articles that I put up on the prior screen cover all of these areas. So some people are quite surprised when told that what we're talking about in property is all of these areas in the law. Marriage and family relations are involved, civil and political rights, of course, land rights, right landlord-tenant and adequate housing, intellectual property interests, access to credit, social benefits. And another issue that comes up, very common, of course, is domestic violence, where women are inordinately the victim of. And in many cases, property issues come up because women who have suffered or are suffering from gender-based violence need tenure security, security in the home, even when the home could be leased in the name of the abusive husband or owned solely by the abusive husband. So CEDAW, and I'll mention a few of the cases, make sure that just the fact that the husband has the formal right to the apartment or the home doesn't mean that the woman cannot be protected, and she has the entitlement to a protective order that can mean that she has the apartment and access to it, not the husband. So next slide, please. So these selective views would illustrate more concretely when a state ratifies the optional protocol and has the duty to respond to individual reviews. These are some of the cases. So in the Tanzania case at the top, it's one of those cases where two widows have been the subject of property grabbing. In that case, by brothers-in-law who seized the property and left the woman, the two widows, destitute. They complained to CEDAW, and CEDAW affirmed that that was a violation of various provisions of the convention, whether or not it was backed by Tanzanian law. Adequate housing involved North Macedonia. In that case, a group of Roma women, all of whom were either young mothers or about to give birth, were living in shelters, illegal shelters to be sure, in a urban area in North Macedonia. And one day they arrived home to discover all of their homes had been bulldozed because the city had decided to permit a developer to come in. They complained that they had not been given any notice and were basically the subject of a forced eviction. And the CEDAW Committee affirmed that that was a violation, that even though they were informal, illegal tenants in a settlement, they were entitled not to be subject to forced eviction. And they were also entitled under Article 14, adequate housing. And remember, Article 14 applies formally to rural women, where these were not rural women, but the committee had no problem finding that they were also entitled to adequate housing. In this case, if no other place could be found, adequate housing to be provided by the government in North Macedonia. In the case of the Netherlands, this is a very typical case where pension rights delivered either by the government's pension rights or by a private employer are restricted by a number of years where you have formal payment by a company, that is, you are subject to paid work. In Block v. the Netherlands applied a policy that you had to have contributed formally 7 years to in order to get your government pension. And many women, and there was a formal complaint by Ms. Block here, were, of course, responsible for disabled children, the care of relatives, and they missed out on a couple of those years. And the committee said that women's work, informal, unpaid work, should count towards pension rights. And therefore, the Netherlands had to change its approach to social benefits. And then the last group is related to the picture that is shown here. That is, women who have been abused. In the picture, as you see, even though it's from the United States, it's a typical scenario around the world. You see she has a black eye from her abusive husband. She has had to find and scrap together money to change personally her own lock on the door to keep the husband out through her own means, because the police wouldn't help her, the courts wouldn't enforce a protective order. And many communications, as you see here, from Hungary, Austria, Bulgaria, Finland, Russia, and also the inquiry reports on Canada and South Africa reflect a scenario where either the law doesn't protect women in those scenarios, or even if it formally protects women in those scenarios, it does not enforce the law to give them access to their home. Next slide, please. So the critiques of CEDAW include the critique that's based on the notion that I mentioned before, that it reflects Hernando de Soto's notion of what it takes to really economically develop on a neoliberal model. And so the critique of not just CEDAW, but all of human rights, as suggested by this book by Jessica White, The Morals of the Market, is the idea that human rights is basically enforcing the morals of the market. The picture that you see is the Chicago School US economist who came down to advise Chile on the shock treatment that it needed to supply, which of course was devastating to vulnerable groups, including women in Chile, in order to privilege private property, encourage commodification, privatization, deregulation, globalization. That is what we have called neoliberalism, or the Washington model for development. And the critique goes on to say that basically human rights regimes, including CEDAW, doesn't really address the structural root causes of women's subordination. It just deals with the surface of it, focusing on only whether the law formally requires equality, and that it too often just looks at the public sphere, what the government is doing, and not the responsibility of market actors for women's inequality. The critique also suggests that what these human rights regimes, including CEDAW, does is it basically tries to export the desires, the wishes of Western women, and ignoring group rights of, say, the indigenous in other contexts, especially in the global South, and that it elevates sex over other forms of subordination, whether it is because of culture, ethnicity, and so forth. The bottom two are particularly strong critiques that you find in the literature, that human rights, including CEDAW, legalizes what ought to be a political struggle. It diverts attention to filing a complaint before CEDAW that is a legal complaint that in the end of the day is merely a recommendation, and diverts attention to what should be a political struggle, demonstrations on the streets, political demands made on local parliaments, on executive branches, including agencies of government, which relates to the last critique, that by focusing on international human rights, it internationalizes what ought to be a local issue. It focuses attention outside of the state instead of inside the state. Now, what my book does is it says that basically, if you look closely at what CEDAW is doing, these critiques are vastly overstated, that CEDAW does not defend neoliberalism policy, that it does try to address root causes, that it does try to address the behavior of market actors, and that it does not universalize a concept of one essential woman, but actually applies a very complex intersectional discrimination analysis, which considers how women in different parts of the world are discriminated against, not just on the basis of sex, but on the basis of their Roma ethnicity. In the case of North Macedonia, it pointed out that these women were suffering because of poverty, because they were Roma, because they did not have access to all other social and other benefits in North Macedonia, and because they were single women that happened to be pregnant, or single mothers responsible for the care of young children and facing undue burdens because of that. And it's the complexity of all of those identities that led to the situation that they faced. The other thing I would also add, and the book tries to make the point, is that the reason human rights have faced a backlash around the world is because they're not just legal, they're political. That is, recognizing equal rights for women, including for property, leads to political demonstrations. So it is a binary, a false binary to say legal struggles are all on one side and divert attention from political. And the other point is that it's not just at the international level. CEDAW is reflected in what happens and struggles in national courts. So there are hundreds of opinions that from national courts, where national courts have looked at CEDAW's jurisprudence, at the text of the convention, to interpret their own national constitution, their own national laws, so that CEDAW, it's too restrictive to think that CEDAW only operates in the context of Geneva, operates outside of the context of states, and only intrudes that way into what states actually do. Next slide, please. So the lessons from property jurisprudence that we draw is that the CEDAW Convention has evolved over time, that it rejects this neoliberal agenda, that it avoids binary concepts and through the embracing of intersectionality, and that it does intrude on both the private side of things as well as the public side of things. And therefore, there is a continuing need for CEDAW to scrutinize national laws, and it doesn't matter whether the country is a poor or a rich one in the West or elsewhere. That is, the continuing need for CEDAW's ongoing scrutiny applies everywhere. Next slide, please. But when you look at a regime like CEDAW, at least when I do, I try to be objective about it. This is not a celebration, or it's not intended to be a celebration of what CEDAW has been doing on property or anything else. There are very serious problems institutionally, bureaucratically, with how CEDAW operates. Some of it is not due to the committee itself, or even those who appear before it, or file NGO shadow reports, but it's because of the UN bureaucracy that surrounds CEDAW and all the other human rights treaty bodies. So the UN bureaucrats are the ones that decide, for example, that a complaint by a woman filed formally before CEDAW is inadmissible because it doesn't have the satisfactory legal criteria. Alas, the UN bureaucrats do not examine why that complaint fails, or they do not have the access to technical assistance to enable women around the world to have access to lawyers from NGOs, or to enable them to know that there's such a thing as CEDAW to begin with. So when you look at the chasm of property rights that I described in the first few slides, and that translates to a treaty that applies to the whole world, practically 189 states, and 114 of them permit individual complaints, you got to wonder that in 40 years, it's only produced 15 individual complaints on property. And the answer is, when you look at those complaints, and they're mostly filed by European, or by women in Europe anyway, that's where the NGOs, the lawyers' access is the greatest. But women around the world outside of Europe may not have that access, and the regime does not provide for technical assistance or any other kind of assistance to enable women to have access to the lawyers that would be able to draft the kind of complaints that would satisfy the UN bureaucrats. There are other constraints imposed by the UN, such as the fact that a general recommendation by CEDAW can only have X number of words, the same with respect to concluding observations or with respect to views. They impose limits on the amount of time that the CEDAW committee has to examine the state reports, to examine a particular view. And there is, of course, the problem that I illustrate here, that as we all know, there's been a huge amount of sovereign backlash against human rights. And it's not just that many states imposed reservations on their acceptance of CEDAW to begin with, many of which violate the object and purpose of the treaty, and the committee has not hesitated to say so. And many of those reservations have not been removed. But beyond that, there has been greater and greater resistance to the types of recommendations that not just CEDAW has made, but other human rights bodies have made. Another problem is that the international law and its regimes do not speak with one voice on how it protects property. There is a fragmented notion of the protection of property, where the investment regime under investment treaties can say one thing, and the CEDAW committee may say another, as well as other human rights bodies. So international law may give mixed guidance to states on how they should deal with the property rights of including women, of course. And then there are the committee's own problems. It is itself a body that only has some lawyers, and that's good in some respects, that it has sociologists and political scientists and diplomats. But that means that when it produces legal work products, they're sometimes not produced by lawyers and suffer from that consequence. Next slide, please. So that means that because of some of the things we're talking about, there are lots of gaps in the jurisprudence produced by CEDAW with respect to property. It doesn't always adhere to a consistent interpretation of the particular articles of the convention. It is sometimes very deferential and diplomatic to states. And in my book, I talk about, for example, the response that CEDAW has had to Chinese reports over time, where they do not go into in great depth the many, many issues facing especially rural women in China with respect to access to agricultural land. Even though they may formally have rights to title, it's agricultural cooperatives and culture that may restrict their real entitlement to agricultural land, as well as, not just in rural areas, Chinese women's access to divorce, where frequently it's the husband that has to give consent if they actually want one, even when there is domestic violence asserted, and that it's the consent of the husband that may drive women to agree to give up their marital property in order simply to be safe, say in a domestic violence where she wants a divorce. So the committee has seen these problems, but what is striking is in the concluding observations with respect to China, it barely mentions them, and there is no real attention to the detail of why this is happening in China, even though the reports that I'm describing are 9 years apart and not much has changed. In the reality, the committee reports are quite laconic, quite deferential, and they're uneven, so that there may be much more intrusive with respect to other states than with respect to, say, China. There are lots of problems that you can see on this slide that deal with other gaps in the jurisprudence of the committee. Sometimes the committee suggests that equality demands a certain minimum level of access to housing, minimum level of social benefits, and yet the committee has not been clear on when that minimum level is triggered or how it should be different depending on the context of particular states. So those are some of the lack of clarity. There's also lack of prioritization. I would think that a woman who faces domestic violence, threat to her life, that should be at the very top of the committee's list of priorities. And yet, in concluding observations, the committee often approaches state reports in the actual numerical approach that they appear in the convention. So because marriage rights are in Article 16 and access to housing are in Article 14, that could be at the very end of a very crowded Geneva session, and therefore may get much shorter shrift than, for example, earlier rights in the convention. That's just a detail, but it shows some of the bureaucratic problems that are faced by this. Next slide, please. And I know that I'm running out of time. My book is, despite these challenges, suggestive that people have ignored the transformational promise of the CEDAW's jurisprudence. That is, despite the enforcement problems that CEDAW faces and many other bureaucratic problems, there is huge potential here if you take seriously what the committee has done over 40 years to really think differently about property, to have an impact beyond Geneva, where it's not just the committee, but national legislatures, courts, municipalities take CEDAW seriously, and some have. And that what CEDAW does through the interpretation of a treaty can have an impact on how we use, for example, policy instruments like the Sustainable Development Goals, and that it also should be of interest in a more academic fashion, perhaps, to those who think about property, to make sure we think about it as beyond traditional Blackstone despotic exclusive possession or property as a civil right, but rather what property protects, the values that property has, and its contribution to Amartya Sen's concept of developing the human person through a full human capacities. So what CEDAW has is a transformational promise that could inspire a redefinition of property, a redefinition of what constitutes discrimination, so that, for example, forced evictions, as I've mentioned, become a violation of substantive equality and are something that is an entitlement. And that means that it's not an entitlement because someone has a lease, but simply because they have a right to adequate housing and not to be discriminated against that. And it also means that we would have an instrument here that prioritizes women, prioritizes individuals, prioritizes human dignity over, for example, economic globalization, so that the CEDAW Committee criticizes a state that would emphasize economic development by permitting agribusiness to come in, and because it will promote additional exports and grow the economy, but at the risk of destroying what are usually female-owned family farms. So that this is the opposite of neoliberalization, and why it's so unfair, in my view, to associate the CEDAW's property jurisprudence with that. Finally, last slide. So I want to end here. So many feminists are quite familiar with Virginia Woolf's Room of One's Own, a 1929 essay in which Virginia Woolf pointed out the need for artists like her to be able to have a key and access to their own room and a modest income in order to fulfill themselves as artists. The picture here on the left is, I think, the Victorian-style room that Virginia Woolf had in mind. What CEDAW does is it universalizes that aspiration. It does not insist that the woman have a key to ownership, but it does insist that women, even here, this woman in Habib a Muslim woman should have the same access that Virginia Woolf aspired to in order to fulfill her own capabilities, as Amartya Sen would have said, but also her own economic empowerment. And let me stop there. Thank you very much.
Okay, Jose, I really want to show your last slides where you have the beautiful picture of your book cover.
Thank you.
So thank you very much for your wonderful presentations, and I learned a great deal. And now let me invite my colleague, Frank Xinhe, to give his comments, feedback.
Thanks, Angela, and thank Jose for this wonderful talk and wonderful book. It's really a pleasure to read a part of the manuscript, and I really learned a lot from that. Let me have one disclaimer at the beginning. So I'm not an international law person at all, right? So I have done some research on gender discrimination, but basically within the jurisdiction of China, so not even to Hong Kong. So so in a way, like I find it somehow incapable, right? So incompetent to comment on this wonderful book. So in a way, like so I may just have some reactions or just comments or suggestions. So I don't know if that's appropriate. So just please excuse me for my ignorance, right? So in the first the first point I want to make is that I think the assessment on CEDAW is very fair and objective. I think if we compare the economist emphasis on the title thing, right? So and then to see how broad the CEDAW rights have covered, and then the words they're using, right? So they're carefully avoid using the property rights, the term, right? So because we all know that it is those right. I mean, we can't really agree upon like exactly what constitute the right. It is a social and legal and cultural construction, and then a lot of things are in closely related to property right. Right. So other form like domestic violence, which I have done some research, and protection orders, and all related directly or indirectly to property right. So this is just impossible just to have some technical terms or rigid system to say like what is property right and what is not. So I think the CEDAW approach, or in Jose's term, CEDAW's jurisprudence, I think is very appropriate. It's broad enough and it's cover a lot of things. You also have certain mechanism to enforce. I think, and then it's really helpful. Like to Jose didn't mention this, like, but actually it's one chapter of his book, like, so compare the CEDAW system with the international investment arbitration regime, like Sam, to see how limited they were, right? So, and they are, like, and CEDAW has become more expansive and then cover a lot of things. I really like the term substantive rights instead of, like, some technical stuff. So, my question, like, I'm a Royal Society person in a way, like I'm not an international person. So I'm more curious, like, to what extent those rights are implemented. Jose does mention that some criticism, I'm not so sure it is right or not, like, on CEDAW's jurisprudence, that it is based on the so-called Washington consensus. And then he also mentioned that actually CEDAW is not really, consistent with that, because CEDAW also stressed that we need more regulation, right? So we need to actually be active, like, in pushing the national states to have more regulations, have more definition, and then have more implementing regimes. So I'm just curious if it is possible to have two jurisdictions, one from under the philosophy of the Washington consensus, one is under the philosophy of the Beijing consensus. Like, I mean, to compare these two jurisdictions to see how CEDAW would implement it and how CEDAW has really transformed the real situation. I'm not aware, like, I mean, whether we can pick those similar jurisdictions. And but we can learn from the previous studies, like, I mean, who have done those comparisons from two similar jurisdictions, such as, like, I mean, Hong Kong or Singapore. But unfortunately, I find Hong Kong and Singapore are both accorded to CEDAW. Right? So it would be nice if, like, I mean, we have some, like, I mean, two jurisdictions with very similar social, cultural and legal systems, but actually one follow CEDAW or one does not follow, one belongs to one camp of the Washington consensus and the other belongs to the Beijing consensus. And then we'll see, like, I mean, how things has been actually implemented and what difference does CEDAW make in this process, right? So, but I'm sure that's really beyond the scope of this book. Like, and this book make enough contribution, like, I mean, in doing those analysis, assessing the framework or the jurisprudence of CEDAW, right? So another thing I'm just curious, like, I mean, so I understand, like, I mean, discrimination is diffusing, right? So it's everywhere, especially gender inequality. So that exists in almost in every corner of the society, and then it's just impossible to eliminate that from one treaty or one international convention. But the effort actually is of CEDAW is just great. So, but my concern is that if CEDAW just have a very broad and flexible definition, like, I mean, so it addresses a lot of things, but actually, could that be an excuse for the national states to avoid their responsibility, right? So we know, like, I mean, equal protection for both genders are there. So, but in the case, like, I mean, in the Chinese court, like, I mean, which I'm so quite familiar with, and there's a lot of ways to evade. I mean, they can define the equal protection in different ways, right? They can seek your consensus, like, through mediation, and then they can use one thing and like, I mean, domestic violence or child custody. I mean, to trade with property right. Or, I mean, there are many ways to play with those terms. So I just wonder, like, I mean, if such a loose or flexible definition actually would make the national states less accountable for the mission, for the commitment of equal protection. Anyway, that's just my my reaction and naive comments. So thank you both. I look forward to read the whole book.
Thank you, Frank. Now, I mean, Jose, I don't know what you want to respond, but I also want to remind the audience that if you have questions, please put in your questions in the chat box. Jose, would you like to briefly respond to what?
Well, only if there are no additional questions, because I certainly would welcome comments and questions. I mean, some of what Frank has indicated is anticipated in the book, in the sense that one of the challenges all human rights regimes face, global ones that don't have a court attached, especially. So I just remind listeners that there is a regional court of human rights in Europe, one in Latin America, the Inter-American Court, as well as an African Court of Human Rights. And that's a somewhat different animal insofar as those courts purport to issue legally binding decisions. They face their own constraints of enforcement. But the European system, for instance, has thousands of cases issued with respect to human rights, including with respect to property. And what the book does not do is engage, it tees up the question, and we hope that it will encourage what we call comparative property jurisprudence. That is, compare international regimes so that eventually we can look at what the inter-American system does with respect to women's property, the European system, and then the African system, but also these UN bodies. And some of them also deal with women's property rights, even though they're outside of CEDAW. So one of the issues that I think the book tees up is precisely that international law does not speak with one commonly with respect to what is the international law of property. And I think Frank is right that that fragmentation itself provides states with forum shopping opportunities. They can say, I'd rather have this issue raised here, and I'd rather respond to it in this regime where I'm more favorably inclined than under, say, CEDAW. The other thing that favors states is precisely the lack of bindingness in what CEDAW can do. CEDAW is not like the European Court of Human Rights and issues binding judgments and rulings that states are formally supposed to comply with. And they're certainly not capable of issuing awards that you can take to courts around the world to enforce, unlike, say, the investment arbitration system, which is one of the most enforceable ways to do it, so that it is almost natural for people to think about the international law of property. And many people have, by the way, described it as such, as being limited to just the investment regime and the European Court of Human Rights notion of possessions. And if that's your view, that is quite different from what CEDAW does. So one of the reasons for the book is to focus attention on what's been going on for more than 3 decades. That is a quiet revolution in how we think about property occurring in this little corner of Geneva, and with some courts taking it seriously enough to enforce it domestically, and not just courts, but some legislatures who have incorporated CEDAW's jurisprudence into changes in laws, legislation, regulation, including in family law. I guess the only thing I would say is that, in response to one of Frank's comments, is that I don't, despite what I've said about the jurisprudential gaps in CEDAW's production of law, I wouldn't say that it errs on the side of vagueness all the time. That is, if you look at the concluding observations, it is quite consistent in criticizing states as different as China and Singapore. The problem is, of course, that both China and Singapore may not choose to enforce it, to enforce what the committee says. And part of the problem is, I think, the lack, especially governments that lack local, powerful civil society that would take up the cause of what CEDAW says. So I think it's a different case when CEDAW issues a judgment or a view, let's just say, or a general recommendation or a concluding observation in a state that has a very active civil society that then uses that to go back to the government and say, what have you done to comply with this? But if there is no such civil society, or if the only Chinese, say just Chinese women's group happens to be sanctioned by the government, then you can't expect civil society to take up what CEDAW does. And I think the flaw of the enforcement regime is that because states have set it up, they have protected themselves, at least globally, from direct enforcement by a UN body, and it leaves it up to states and their own political dimensions to enforce. And that means unequal enforcement of CEDAW in various places, not so much because CEDAW itself speaks inconsistently, but because the states are structured differently politically, with civil society and so forth. So if you take a look at the latest, which I just have because I'm now sitting in Singapore, the concluding observations issued with respect to Singapore from CEDAW, it is quite harsh on, for example, how Singapore has decided to lay off a Muslim population. Religious edicts are not examined closely with respect to property rights, inheritance rights, equal rights. The CEDAW Committee criticizes Singapore's permission for polygamy, where Muslim men are permitted 4 wives, for instance. It does not hesitate to say that that's a concession to a religious minority that violates the convention. So even a state that follows a market economy is subject to serious criticisms, certainly as much as you would find in the Chinese concluding observations.
Well, thank you, Jose. We actually received 4 questions so far.
Great.
Actually, one of them, you did kind of dealt with one of them, which asked about the potential conflict between social cultural pattern like polygamy and CEDAW's suggestion to modify this kind of, social patterns, right? I mean, the potential conflict between the religions and CEDAW's suggestions,
Right.
how to deal with this conflict.
Yeah, so there you have varying views, with some people suggesting that CEDAW has gone too far and does not sufficiently accept pluralism, cultural pluralism. And they would say that CEDAW should not have said that polygamy, for example, is just a violation of the convention, but that they should be more sensitive to working with states that have an existing cultural norm that is so embedded, and to working with states on ways to modify the rules with respect to polygamy to enable women to have greater respect for property rights, even within that institution. That has led to something of an academic debate, with some people suggesting that CEDAW has not been sufficiently culturally sensitive, whereas others would say it's just an inherently unequal institution, and therefore should be eradicated, consistent with the language in the convention.
Right. Jose, we are actually running out of time. We still have 3 more questions to deal with. Are you able to stay for a couple more minutes?
Sure, a couple more minutes, that's fine.
Okay. Look, I mean, there's a question from Pew Ying Lo. Do you see any influence of the Chinese member of CEDAW Committee in the approach and jurisprudence of the CEDAW Committee? I mean, China is very active, right? I mean, so.
Right, well, that's hard. And one of the things that I didn't say, but I mentioned in the book, is the lack of transparency of CEDAW itself. I don't know if this is because CEDAW wants to protect its members, but for example, the views are not issued in the names of the individual members of CEDAW, unlike many international courts, which permit dissenting and concurring opinions signed by particular members. What we hear is just the committee issuing its views. Very rarely would we find a separate opinion by one of the committee members that self-identifies. I'm not familiar with anything, and remember, with China, this is especially difficult because China is not a party to the optional protocol. So we don't have the one place where you could see it is a separate opinion and say the views, but the general recommendations are issued from the committee as a whole. And therefore, since China is not subject to the optional protocol, there are no Chinese views, no communications that might reveal what the Chinese member might say or not say with respect to a particular complaint. So that makes it very difficult and untransparent with respect to what individual parties do. I suppose the best way to get a grip of that is if someone were to attend the actual sessions in Geneva, to actually see how the individual members of the committee respond to individual complaints that might relate to what their own government is doing. That's not what this book does. So, but that would be, an empirical interview approach. We did conduct a modest set of interviews with some CEDAW members to get a sense of background of how they approach issues, but we did not try to figure out national distinctions, which of course the committee members themselves would resist. Remember, they would say they're appointed in their expert capacities, not as representatives of their governments. But of course, everybody tries to do that, whether it's the International Law Commission or other expert bodies, tries to see how much the so-called appointed expert actually deviates from what their government says. This is not what this book does, but it would be a worthy effort, I think, more generally.
Right. Can you ask one more question? Okay, one last question. On the extraterritorial effects of CEDAW, okay? And ability to make market actors' behavior outside of state boundary, who is expected to respect and protect and fulfill these rights, and who is to be held accountable.
So what CEDAW does is a state-centric model. It does not impose these obligations directly on market actors. It says the state has to respect, protect, and fulfill. So what it says is your state laws are supposed to make sure that your rules against to promote anti-discrimination by your market actors has to apply not just when they're in your territory, but when those actors go abroad. And so that's how it approaches it. The state has to regulate Exxon when Exxon goes outside of the state. And some states do. Now, this is an interpretation of the convention. The convention itself doesn't say it applies extraterritorially, but because it leaves it blank, silent, the CEDAW Committee, consistent with some other human rights committees that have said the same thing, like the committee under the Covenant on Economic, Social, and Cultural Rights that said the same thing. They've said, well, since it's not restricted to territorial jurisdiction, it applies extraterritorially. And we'd have to do a state-by-state look at their laws to see how many states have treated that obligation seriously, to see how many of them purport to apply outside the U.S. The U.S., which is not a party to CEDAW, does, of course, have some rights, including rights against discrimination against women, that do apply to U.S. companies abroad. That was passed by Congress. It was a statute. It was not in response to CEDAW, but because of domestic political pressures that those companies should not discriminate against women wherever they're located.
Wonderful. Thank you, Jose, and thank you, Frank, for joining us for such a wonderful discussion. So, Jose, when will the book be formally published?
And we're told mid-March.
Oh, very soon.
Yes.
Okay. So we look forward to its publication, and thanks all the audience for joining us.
And I look forward to seeing both of you at NYU at some point.
Yes, we'll do. Okay, thank you, Jose, again, and thank you all. I will see you guys next time.
Take care. Bye-bye.
Take care. Bye.